Good afternoon and welcome to the law. The Bible says it is appointed unto man once to die. So, death is an appointment all of us have. After death, how, like they will say in P, will your back look like? Will there be controversies over the little wealth you have been able to make your property? Will your spouse that you left behind, will your children that you left behind, your parents, your siblings, will they be taken care of the way you would? Are you worried about that? If you are, question is, do you have a will? We'll be right back to talk about wills, the essentials that you need to know. Why must you have one? We'll be right back. I'm Samson Ladi Anyanini, and this is The Law. It is your legal light. It is your help law. In a world where the acquisition of wealth and property and leaving an inheritance holds sway, would you want to pass what you have acquired in life to somebody you never intended, or have your possessions shared according to law? Well, let's hear what some had to say on having a will or not.
Sometimes, when you start trying to put out will, it means you are really ready to exit, and the state of mind. And though it's good to do it, especially when you have some people you want to, pass some of your things to, because people will start to fight over these things. It's good to do it, and you need to really put down something for your people, But for me, though I want to do it, I haven't really sat down because I want to live long, and I'm planning, because anything can happen. Though you can just get up and you are no more there. When you start thinking that, look, I need to do this, I need to do that, because anytime I can die, okay? And so it's like you are speeding up your own, whatever. You understand what I'm saying?
I do have a will. And the reason why I have a will is because, in life there are unforeseen circumstances, you understand? And one thing about human beings is we don't really like to disclose our financial statuses, you understand? So in life, if anything happens to you and then you're not around and nobody knows anything about your properties, your finances, or most of the things that you've achieved, you understand, these things can land in the hands of wrong people, you understand, hence making all those things that you've achieved go waste. And we all know that in our setting as Africans, usually when someone is worthy and the person doesn't have a laid down will, it turns out that when the person is no more, the family members tend to mismanage and tend to encroach on all those things. So I think those are the main reasons why I went in for that will. I don't think it's because if you have a will, it's because you are thinking that you want to, or you're about to exit the will. No, that's not it. Eventually everybody will go.
And we the Muslims, for the will, we don't do will like that. When you are alive, you don't do will. We wait after you are dead. Everything followed by the Islamic. as the way you have your property, they will share it among the men. The ladies take smaller, the men take more. That is how we do it. But for we don't share, we don't do will. When you are alive, doing will, putting someone's name, somebody will get higher, somebody will get lower, somebody will get. We don't do that. We don't do that. We the Muslim, we go according to the Quran, the way Annabi Muhammad sallallahu alaihi wasallam, prophet, said it. That is how we go about it. We share it according to how the weight it is. The men.
I think it's for the old people. You have to reach a certain age that you start to do your will for your. And I think that I'm not yet up to that age.
So, interesting views, don't you find them? Well, this afternoon, in our usual way of seeking to enlighten and empower you, we have Kweku Pencil, who is head of Pencil & Co. You remember him on this show. He will take his time to let you know all that you need to know about making a will. Yeah, thank you once again very much for making time to come here.
You're welcome.
Right. So let's start right away from the comments that we have heard. There was this gentleman who said making a will is important because, you can't tell what will happen. Then the first one who said making a will suggests you want to speed up your death. You've heard this over and again, right? What do you say to people who say that?
Well, the comments that the people have made reflects the perceptions and misperceptions that a lot of people have got about making will. I think the first point about a will, a lot of people think that there is a bullet in a will. In other words, once you're making a will, you're pointing a gun, or the will points a gun at you and shoots you after you've made a will. That's a misperception. Also, people think that wills are for people who have reached a certain age.
Yes, that's what the third person said.
People also think that a will has to be made by people who have acquired wealth up to a certain stage. It's a misperception. I think the whole of this is about what you said at first, appointed unto man wants to die. Nobody knows when he's got an appointment with God. And what it means is that before that day that you and I do not know, a will makes it possible for you to distribute your estate in a manner that you want it to be, and to whom and who must get what. And then there could be no better way of living this world. Indeed, the other thing that I need to say about the Muslim is that we've got a law in this country which does not recognize religion when it comes to making a will. You can either live this world in one of two ways according to our laws. Either you live the world with a will, in which case you got what we call a testate estate. Or when you die without a will, we call it intestate estate. And both are regulated by law. By intestacy, meaning a person who died without making a will. And that is regulated by a law we call Pianist Law 111, what we call the intestate succession law. So if you don't make a will, regardless of your religion, you could be a Hindu, you could be a Buddhist, you could be a Christian. And it's important to make this point because a lot of times we have problems, especially with Muslims, because when these issues arise, they know the Quran. But I also know Muslims who have made their wills according to their belief system.
That's right.
And therefore, being a Muslim does not itself stop you. On the contrary, the doctrines that are in your Quran is what you must use and make the will in your own lifetime, according to your belief and your understanding. So that's the first point that a lot of people need to understand. That's got nothing to do with religion. If you die with a will, what it means is that you have had opportunity yourself in your lifetime to decide who must have what of your estate. And therefore, that's the starting point that people need to appreciate.
Right.
You will have a will or you don't have a will.
Okay. Now, having started on that note, you started using the word estate. In the course of the program, our viewers and listeners are going to hear you use testator, beneficiary, executor. So explain to us so that we start, everybody can be on the same wavelength with you. What is estate? You say estate.
Essentially, when we talk of estate, we're talking about, I mean, your lawfully acquired properties, everything that you acquired during your lifetime, everything that you've got an interest in, even if you've got reasonable expectation to know or to believe that there are properties that may be yours even after your death, or even if at the time of making the will it is not yours, but then you have reasonable expectation of acquiring them, it becomes part of what we call your estate. Essentially, everything that you lawfully are entitled to, however you acquired it, as long as you've got an interest. There are things that you may even be, you may own it together with others.
Okay.
Your portion of what you own is what becomes part of your estate. Your money is in your accounts, call it properties. We're talking about, when we use property, we are talking just about everything. We're talking about real property in the sense of burdens. We are talking of lands. We are talking of farms. We are talking of, I mean, bonds, securities, just about everything.
All right.
Those are your properties. And that's, in the legal terminology, we call it estate.
Right.
As long as it falls to be distributed.
Right.
And according to your wishes.
So now you're going to go into who can make a will, cannot make a will, what are the requirements for making a will. Then we come to talk about why it is most important. So, like I mentioned, you have explained estate. We'll meet testator, we'll meet executor, we'll meet beneficiary. Who are these people or characters in a will before we go into what ought to be in a will and how you can have a will that is recognized by law?
A testator is essentially the maker of the will.
All right.
We call it testator if it's a male. We call it testatrix if a female. Though we use testator all the time, but
right.
I mean, we need to differentiate it. The same way we've got administrator for a male and administratrix for a female.
Okay.
That's for those who die without a will. But we are talking about wills today. Then we're talking about a beneficiary. A beneficiary is anybody who's entitled, who has been named to receive a bequest or whatever, call it gift. Maybe sometimes I like to use words that will make meaning to the people who are hearing. Everybody who has been named in a will to receive something in a will is called a beneficiary. So therefore, if I say that this person must take this, you are a beneficiary. The other term that you talked about was
executor.
An executor is a person who is named in a will to stand in on behalf of the testator after his death to carry out the wishes of the testator. In other words, a testator may distribute properties in a particular manner, a particular formula.
Executor.
It takes somebody called an executor to take probate of the will. Probate essentially is going to call to have the will formally, what do you call it? We say probated an estate for the court to empower you to distribute the estate in accordance with the wishes of the testator. So that's an executor. It could be one, it could be two, it could be three. I mean, it's the choice of the testator who he wants to be an executor of his estate. So there is a trustee relationship. In other words, when you appoint an executor, it's a power, it's a position of trust.
Okay.
And you have to discharge the duties in accordance with how you have been appointed. And failure to do this may find you in trouble because it's an executor may waste the estate, may be negligent, may be whatever. And if you do that, the beneficiaries of the estate can take you on to a court action or whatever.
So very plainly, he's explained to you the estate, the properties. He's explained to you the testator, you the one who is making the will. He's explained to you the beneficiary, the one who will get a benefit from the will, who has been named. I'm sure that during the discussion, he will make us understand that some may not have been named as a beneficiary, but they may also be able to benefit. Then he has explained the executor, the one that you, the testator, you trust to take care of your estate in your absence by way of going to court to get what is known as the probate, so that officially you can now begin to take care of the property of the person for the distribution of those who must get one. Now, what will you say are the importance of making a will? Why is it important to make a will?
That's a very interesting question.
Yeah.
I mean, because then you've got, I will list as many, but let's put it this way. When you make a will, you have an opportunity yourself to determine who takes what. There can be no better way of using your freedom than by doing that. And therefore, it forecloses or prevents a situation where people who, for whatever reason, you may not want to participate in the distribution or the benefiting from your estate to participate in any way. That's point one. Point two is it gives you also an opportunity to be able to name what your estate consists of.
Okay.
Because there's a lot of confusion most times when people are dead. And I'll tell you this because, see, we are part of society. We live in a country where sometimes the relationship between husband and wife, because of this polygamous system of whatever that we have in this country, a man may live with a wife, but the wife doesn't know anything about him.
Okay.
A woman may live with a husband, the husband may know anything about her. And what it means is that by reason of these United Nations homes that we have in Ghana, a man who's got 5 wives with 11 children, 13 children, so the man really can't disclose everything.
That's what United Nations
for. Right, to the various parts of the families, and then when he dies, there's always an issue as to what he really owns.
Okay.
Quite besides that, I mean, let me tell you what, there are things that we may have which are with other people, like I say, and then once you fall dead, that's it. If I came to live 100,000 cities with you and I died in a lorry accident, how many Ghanaians will really come up and say, Mr. Painting left 100,000 with me?
Okay.
They wouldn't do it.
Right.
So, the basic thing, the real thing is about the freedom that you have in your own lifetime to determine who must have what. I think we can say so many things, but that is the ultimate.
Right.
That's the ultimate. Right. And all other reasons may be subsidiary to this one. But that's about, for me, as far as I can think of it, the best reason that anybody can have to distribute his estate. Yes.
Right. You are here on the law. This is your health law, and it is your legal light. And we're having a conversation with Kweku Pencil, who is head of Pencil and Co. law firm. And in due course, we will, as always, give you the opportunity to call in, ask your questions, but we are empowering you on the need to make a will and how to make one that will be recognized as a valid one. So, when we say a will, is it not okay for me to pick a piece of paper, sit there, write whatever I want to give to whoever, and give it to any of my family members to keep, or my children, or put it under my bed, and in my absence, they simply pick the paper and say, this is what I said I want. So they go according to that.
You see, a will is what we call a testamentary script. In other words, it's a writing on paper made by a testator. But we've got a law that regulates the making of wills. And in doing that, in writing what you want to have written, it must conform to the law.
Okay.
And the conformity with the law starts with a writing, because that's the essential character of a will. Of course, there are qualifications for soldiers in active combat who need not make a will in writing. But even then, there must be 2 witnesses to whatever oral will that he must make. That's also distinguished from what we call non-cooperative wills, the oral will under customary law. That's also quite different. But here we're talking about Act 360, which specifies the form in which a will must be made. And the formality includes that it must be in writing and it must be signed by the testator. It doesn't end there. There is also a requirement of there being witnesses, at least 2 witnesses. And the 2 witnesses must be present in the presence, or rather must be present, of course, in the presence of the testator. And the testator must sign the will in the presence of the 2 witnesses, and the 2 witnesses must see the testator signing it in their presence. And at the end of it, the witnesses must also sign, each of them, in the presence of the testator and the other witness. So it takes 3 people at the very least, because there are situations where more than 2 witnesses are required. If, for instance, there's a witness who's also a beneficiary of the estate, then the law requires that in addition to that witness, there must be a 3rd person who must also witness to that beneficiary, just to put things beyond doubt. So to recap, there are minimum of 3 people who must be present together in the presence of each other, and each of them must sign in the presence of each other. The only qualification that I need to make with regard to that is that the witnesses need not know the content of the document.
Exactly the question I was going to ask. Because if you have so many around the place, everybody's going to see. So what is that?
They didn't know. Because a lot of people, I mean, they want to probe. They are nosy and whatever.
Okay.
If you have to be a witness for a will, the law does not make it obligatory that you know the content. If, of course, the tester won't let you know, that's his business. But if I'm a lawyer and witnesses come in, one of the first things that I advise them is the fact that you are there just to ensure that in any time, any situation where an issue arises as to the freedom or the willingness or the voluntariness by which the executor, I'm talking about the testator executed the will, then you can bear witness to the fact that you were personally present and saw the testator execute the will in your presence and also in the presence of the other witness.
Okay.
Those are the formalities. I'm talking about the formalities.
Right.
Obviously, the other formalities as naming and executing and whatever, but we are talking about certain formalities, non-compliance with which could be fatal to the execution of the will.
Okay.
So these are the essential formalities. The executor in the presence of two witnesses must sign to the presence of those who each of them must sign in the presence of the other.
Right.
Those are the essential formalities.
Okay.
Obviously, there are other requirements of law, non-compliance with which can also make the will void. That's contained in Section 1 of Act 360. That deals first with age. There's a legal age by which a person must make a will.
Right.
The law requires that a person must be a minimum 18 years in order to be able to make a will. So that's the first point. There's something in law we call compos mentis. That is to say, testamentary capacity. In other words, a person must be of sound mind in order to be able to make a will. So that if at any point in time there's an issue as to the soundness of the mind of the testator, then the law will say that whatever document he executed cannot pass. We've had situations where there are people who swings between soundness of mind and what we call lucidity. In other words, there are times they become lucid, there are times. The law is clear that a person who's of unsound mind but who swings between sound mind and other mental states, any point in time in the period that the person is lucid, he can execute a will.
Okay.
Then the other point is about voluntariness. The law is quite clear that any time that anybody has executed a will, there must be evidence that he was not induced, either by fraud, by undue influence, by coercion, to have executed the will. These three put together is absolutely necessary. The absence of any one of them can make the will void.
18 years of age, sound mind, and if it is found that the person didn't do it voluntarily, what happens?
It's void. In other words,
voidness means what?
It means that the law, I mean, the document that has come to court, the court will not make a pronouncement as being valid for any purpose. It's for fall.
So 18 years for the testator, the one who can make the will. Yes. But if I want to appoint an executor, I must make sure he's 21 years old.
Minimum 21
years.
You're right.
Okay. Right. You are still here on The Law. This is your Help Law and Legal Light. We are having a conversation about wills with Kweku Pinsel, head of Pinsel & Co. law firm. Get all the education you can to empower yourself to make a will if you don't have one. If you have made one, you are not too sure that is compliant and it might be void, check it again to be sure that it is correct, so that in your absence, there are no fights. In due course, we will open the phone lines and give you the opportunity to ask questions about the will. So, those who spoke to us, one suggested the best is to be a little older. But within that was a suggestion that at that point you must have now acquired something. So if I have not acquired property, what's my business wanting to make a will? Even though the law says I'm qualified to make a will if I'm 18. 18 with nothing. What's the point of a will?
You know, I'm sorry, but that's this set of mind can only come from Africa and can only come from Ghana. Because, see, indeed, one of the essential requirements, not essential requirement, I'm talking about one of the requirements of, I think Section 1 of the Act 360 talks about anybody with a property or who is likely to have a property, whether in his lifetime or after his death.
Right.
And that also explains everywhere that we make, there's something that we call residuary estate.
Okay.
That is to say things that at the time even of making the will, you have not got it, but there's a possibility that, I mean, you may acquire it during your lifetime.
Okay.
You know, we say when there's life, there's hope.
Right.
So let's put it this way. Look at Lady Diana. At what age did she die? At the time that she died, she had a will.
Right.
I'm not sure she had an idea that she was going to die the week that she died. But then there must be something within the system that make people put their act together before the day of death. Those are the kind of things that it's about time that we start encouraging in our society. And may I say that lawyers who make wills are the worst culprits when it comes to making wills. They don't make one for themselves. And the evidence abounds in our court of law.
That's true.
All the lawyers who died, they have made no will. We are making wills for everybody.
And there's such bloody fight over their estates.
Believe it. And women also, for some very strange reasons, they don't make wills. But I'm not here to quarrel about whether women make wills or not. But I think I'm answering your question.
Right.
And that's my own view about this subject.
Okay.
Now, please don't wait till you've acquired even things before. Because, doom spiro. I've told you about, when there's life, there's hope. That's the Latin expression, doom spiro. Right. And interestingly, because we're in a country in which everybody is a Christian and everybody has got a lot of hope, and no matter where station in life, you still believe that you're going to acquire all manner of things. So please, let's put it this way. If you've got nothing at all, there can always be one clause that you can put in there in which you will indicate that whatever that you acquire in your lifetime must be distributed in a particular manner. Maybe you give all of that to your spouse and children and so forth and so on. So whilst people may have a reason for not wanting to do a will merely on the basis that they have acquired nothing, fair enough, that's their issue. But speaking on this subject, and with my experience on this subject, I would tell people that the least that they have, even with their salary, their bank account, they should not own a house at Makati here, nor should they have a house at East Legon. They can even make arrangement for even their bank account, how it can be distributed.
Okay.
And it's a good enough reason for making a will.
Right. So if I make a will, I know what you, the lawyers, say. A copy goes to the court, the high court, and they keep it there in custody. A copy comes to me, the one who is making the will. And then another copy goes where? About 3, sometimes as many as 4 copies. Now, the question I'm asking is, if I have made the will already, and then it's gone to the places where it's supposed to be kept, and I want to change it, or I'm not interested in it anymore, what can I do? That may be the reason I don't want to make a will.
Yes. You know, there are 2 different things that you're talking about. There may be a situation where a person wishes to revoke the will. In other words, you don't think it's necessary at all to make the will. The rules provide that in those circumstances, you can tear it up. You must destroy it. For people to see that you have destroyed the will. There are other ways of revoking a will. You can also revoke a will by another document. Because typically, every time that we make a will, what we say is that this will, I hereby revoke all former testamentary scripts and whatever. That's just a usual clause that we put in. But if you fail to put in that clause and you happen to have had a will before, then the law is that the provisions of that will remain only to the extent of inconsistency. That it does not conflict with anything in the current will, but if they do, the current will always override the provisions of the previous will. So let's put it this way. If you've made a will for any reason, you think that you don't want it, you can revoke it by a formal document by which you can, alternatively, you can destroy it. That's what the law
I've changed my mind. Yes. I wanted my first boy or my girl to have this. I wanted my father or mother, if I predeceased them, to have that. I've changed my mind. I wanted my friend also to have maybe my car or a house. I've changed my mind. What do I do?
There's a document we call a codicil. A codicil is essentially an amendment to a will.
Okay.
And the codicil will then recite the changes that you want to make in the old will. But we'll typically, for convenience sake, we would normally advise that you make a new will all together in which you may recite the new provisions and those earlier ones that you do not want. Because sometimes it happens that even there are properties the person has made a will, in the course of 10 years, sold them. Sometimes somebody has made a will 10 years. Over the period, a lot of things have happened and some of the properties are not even there at all, and so forth and so on. In those circumstances, it's easier to make a new will in which you make a fresh list of what you have and what you do not have. Other than that, you make what we call a codicil. A codicil, like I said, you recite, the amendments that you want to carry out in the old will. And that document itself becomes more or less an addendum to the old document that you have. So that's a very convenient way of changing your mind. It happens regularly.
Right.
Yes.
What do you advise? And shortly we'll be opening the phone lines, and also you will be able to join us via Zoom. If you have been watching, you see that we will advertise the Zoom details and the phone numbers as well. But don't call until I say call. What would a couple that want to make the will together do? Is that allowed? Or they must make it separately, and then one will say, if I predecease you, then you get this. If you also predecease me, you also get that.
In my own experience, the law permits wills that are made by a couple, for instance, or any two people can come together and decide that the property that they have, they want it to be bound by particular rules and regulations they themselves will make. The law permits it. There's nothing really that stops it. And then it can also go through the normal processes of registration. But I think the other thing that you made, maybe which I need to comment, when you made a will, all that the law requires is that a copy must be left at the registry of the High Court.
Okay.
And the law also makes it incumbent that anybody who's got a copy of that will, upon hearing of the death of the testator, it is incumbent within 2 weeks for you to lodge a copy of the will or the testamentary script or the document that's in your hands in the registry of the High Court. Failing that, or if you've put it in any of the courts, the law permits that the district court, the circuit court must transfer it to the High Court.
Right.
But if you fail that, there are criminal sanctions. I think under the law, you can be sentenced for a minimum 10 years. Not more than 10 years. And 10,000 Ghana cedis, which essentially is a very strict liability law. In other words, the burden will be on you to demonstrate why you haven't signed the document. Okay. And it also gives you an idea of how the lawmaker considers the conduct of keeping somebody's will with you without sending it to court to be that severe. Right. So that is how our conduct in relation to wills are regulated by law, and shows you the seriousness with which the lawmaker attaches to this whole idea of will making and what an individual can do and cannot do. So that's about how I need to be talking about this issue also.
Thank you very much. And the punishment, and he says if there's a copy with you, you found it somehow, from the point where you find it, you are supposed to immediately deposit it with the High Court, or you should make sure that at any opportunity you are doing so within 14 days after you have had knowledge of the person's death. He says if you don't do that, you are committing a criminal offense and you could go to jail. The law says for a fine not exceeding 2,000 penalty units, and that would be like 24,000 cedis, I think. And then you may also get, in addition to that, up to 10 years in jail, or up to 10 years in jail. You don't want that to happen to you if you found somebody's will or you want to find a way of keeping it. What would be the reason for wanting to punish people criminally for finding a will?
You see, this must be located within the sociology of the politics of funerals and whatever. Some people, discover wills and they deliberately keep it away with the intent that in the absence of the will, they will benefit from the estate. That's the prime motivation for people.
Because I was surprised, I was wondering, because if you are having the will, the executors will not help you because you are not a beneficiary.
Naturally.
So why would you want to keep it?
They steal. And the people steal wills.
So that they make sure there's no will.
That is so.
And then somehow they find a way to enjoy.
That is so.
Okay.
That is so.
Okay.
That's the prime motive.
Right.
That's
right.
the prime motive.
Okay. So you are getting empowered and there's a need for you to make a will. He says that you could have property with somebody, not just yours, with somebody. So that's some joint property. You may have shares in some company or wherever it is. Your portion will be named for you in your will, and that helps even for your own people to get to know the extent of what you have. It is that important. So you have seen the Zoom details and of course the phone lines. We're opening the lines now for you to call and ask your questions about wills, please. To Kweku Pencil. This is the law. It's your health law and legal light. Now, I've asked you a number of questions. Yeah. I prefer not to ask you any question now. What do you want to say? What must be said?
I need to add in a forum like this, I'm speaking to the members of the legal fraternity.
Okay.
Every time, the first point is that wills are regularly challenged in our courts in Ghana. People come to court to have wills revoked for a variety of reasons. I think the context in which I want us to place our discussion is the fact that in Ghana, nobody dies naturally. Even a 90-year-old man, if he were to die today, somebody will have some other cause for his death other than natural. So there's always superstition. Flowing from this general way of doing things is the fact that because the person has not died naturally, people then begin to question every testamentary script that comes out. There are a variety of reasons. People begin to make allegations that at the time that the will was made, the testator was not compos mentis. At the time that the will was made, the testator was being administered a course of drugs that made it incapable for him to understand or to appreciate or to know what he was doing. And my first point is that every time this issue comes up in a court of law, is the credibility of the lawyer who prepared the will which is at stake.
Okay.
And for that reason and that reason only, lawyers can take precautions. There are things, these are not in the law, but these are practical things that you can come, I mean, you can address by way of experience.
Right.
So one of the first things that every lawyer must do, I didn't know this until I myself got involved in a certain litigation in court in which we had to call an English solicitor, he's a Ghanaian anyway, who had to come to court to give evidence. And for the first time, the kind of things that the manuscripts that we regularly throw away, apparently is part of the preparation of a will. When you do a will, you do draft and whatever, you take it to the clients and it corrects and whatever. It was part of his folder. That was the clearest evidence that the testator had participated at the various stages
he was of sound mind.
That is all. And you know, until that day, I myself didn't even know the importance of the testament.
No, you are just telling me. I have not paid attention to that.
We treated as draft and we throw them away. So these days,
I've had people handwrite things that they need me to put into a will, and I've trashed them after we had the final work.
That is
okay.
So it's essential part. So these days, I deliberately, I will even deliberately make a mistake for the client to correct in the spelling of names and whatever.
Okay.
So as he puts, Kweku is K-W-E-K-U. So when he cancels the A and puts E there, that's the evidence that he knew what he was doing.
Good.
That's the first point.
Okay.
The other point is that by the grace of God, now we've got mobile phone, we've got technology, whatever. These days are hardly prepare a will without letting the testator speak into a video, acknowledging that this is his own will and he's doing it on his own free will and identify the surroundings and the people present. He speaks into it.
Okay.
We had one client who lay dying at 37 Military Hospital of cancer. And when the information got to us, she was in a state in which, I mean, like what they say, doctors have declared you. You know what I'm saying? We knew it was going.
Yeah.
But then it just occurred to me that, no, let's video this thing. So we took in a video, hired a cameraman. That time, even these mobile phones were not as popular as this. So we went in there and then let her speak into it.
Okay.
And of course, after making the will, within about how many, 2-3 weeks, she was dead.
I see.
And then, predictably, the struggle started, the whatever started. People started to claim, no, this is not whatever.
Yeah.
You know what I did? I just wrote a letter. Interestingly, the agitation was coming from her own mother. And like she was challenging everything. And this woman had been brought in by a colleague of hers who was a co-worker. And so what I did was to write to them that, listen, we got instructions. And when we got instructions, these are the things that we did. We filmed this thing, but we are not obliged to let you see this video.
All right.
And we have this video, we dare you to go to court.
Right.
And when you go to court, we'll come and show you to the court. That's what ended the matter.
Okay, now let's begin to pick some of your questions. And for those, there are people who say, I'm afraid if I make this will, and I put things in there, it means they belong to the people I have already put the things in there for them. What will you say to that before I pick the calls? You have made a will.
No, but you need not show the will to them. They need not see
that somebody knows that you have made a will, and you know the things you have put in there don't belong to you anymore.
Oh, if they don't belong to you anymore, you lose nothing.
Right.
Yeah, when you die and the will comes out, they will follow it and they will know that you sold it in your lifetime.
Until you die.
Yes.
The will is not effective.
No, after a will takes effect only after your death anyway.
Okay, thank you.
Right.
Bright, for Charles first. Charles, you're calling from Swedro. Thank you for your patience. What's your question?
And my question is, what about if you make a will and maybe later you have an issue somewhere, but just unfortunately you did not review your will and maybe you pass on, what would that person benefit?
Okay, thank you very much. Yes, Bright, you're calling from a brim.
Yeah, my question is, so he mentioned that you're supposed to have at least 2 witnesses. What if people pass on before you, and like he mentioned that if they fail to present this will, they will have to be in prison for 10 years. What if they pass on before you? What will be the action that I have to take?
Okay.
No, it doesn't affect the will at all.
All right.
It doesn't affect the will in any form if they die before you. Even if the executor dies before you, it still does not affect the will. It does not affect the validity of the will.
Right.
The will will still be valid and it will be admitted to probate. Okay. The only thing in those circumstances, for instance, is that if the executor has died, there's such a concept, there's such thing as having letters of administration with will annexed. In other words, then somebody will go to court, apply for letter of administration, attach the will, and whoever is appointed by the court will administer the estate in accordance with the will. Right. The executor is dead.
Okay, thank you. Robert, you're calling from Tema. Robert, your line is very terrible. Hello, Robert.
Hello.
Yes, go ahead.
Yes, so he said that when you do a will and you want to change it, you can destroy it.
In the presence of witnesses. Go ahead.
He said that when you do a will and you want to you can change it by destroying it.
You can revoke it. That's what he said. You can revoke it by destroying.
You can destroy it
in the presence of witnesses.
So what about the one that you have lodged in the court?
Thank you very much. He will answer that. Kerry, you are calling from where? In Chaban? Yes. Let's hear you, Kerry.
Yeah, my question is, how averagely, how much does it cost to engage the service of a lawyer to prepare a will for you?
Okay.
And then the second question too is any lawyer capable of writing a will?
Okay. All right. So please hold on. Let's take answers to your questions first. So Charles, who called first, is asking that if you didn't make provision for somebody, you had an issue. I think I understand where he's coming from. You have a child somewhere, you didn't disclose to anybody, and then you didn't make provision for the person in your will. What will happen?
There is a provision in Act 360 that makes allowance for what we call making reasonable. A court has got power within 3 years of a will being admitted to probate. Anybody, that is to say a father or a mother or a spouse or a child under 18 years, can apply to the court to make what we call a reasonable provision out of the estate for the person. And the court in these circumstances is charged to look at what we call all the circumstances of the person's case, including what other provisions possibly you made for that person. And the court has jurisdiction in those circumstances, having regard to all the circumstances, to make an order to take a provision out of your estate for the person whom you left without anything.
Okay, so for as long as you depended on the person who made the will, the testator, you are a dependent, and he has laid it out, 18 and the rest of them, within 3 years
of probate, that will be admitted to probate.
3 years. If you come after that, you may have a difficulty. So within 3 years, the court can make provision for that person that you didn't make provision for. Then we had Robert, who said, what happens to if I revoke the will simply by destroying it in the presence of witnesses, what happens to the copy that is kept in the court?
The assumption would be that you have withdrawn or you withdrew what was in the court before destroying it in the manner that the law prescribes.
Okay.
But if we assume for the sake of our discussion that you destroyed it in the presence, or you revoked it in the presence of witnesses, and you forgot to retrieve what was in the court, reasonably, evidence can be led to demonstrate that you actually revoked it. That is the requirement for witnesses to the revocation.
Okay.
Other than that, if you want to play safe, do it by a formal document.
Right.
The other thing that I need to add, the impression is being created that a will must necessarily be made by a lawyer. A lawyer is not mentioned in the Wills Act at all. Anybody who can follow what I've told you can make his will. I've had a few cases where people have made their own wills, they got their witnesses, got executors, everything right, and the law will recognize it.
All right.
Other than that, lawyers will become too important.
Okay.
They are not.
So Kerry, your question has been answered. You said, what type of lawyer can you use? Basically, any lawyer can help you make a will, but there are some lawyers who don't, so to speak, have time for will making. And he said he wanted to gauge minimum costs.
It's been very difficult. I'm not allowed to sit on media to discuss issues of fees. That's what we call semi in chambers.
Right.
But please, believe it, sometimes we do this things for free.
Exactly.
I mean, that's the truth of it.
Exactly. And sometimes it can be, it may not cost anything at all, really.
Right.
Let's go to Wesley. Wesley, you are joining us via Zoom. What will be your question? Hello, Wesley. Wesley, unmute and speak. Okay, hello, Mark. Mark, unmute and speak. Hello, Rita. Rita, unmute and speak. Let's hear you.
Yeah, Samson. Good afternoon.
Good afternoon. Go ahead.
Samson, can you hear me?
Yes, go ahead. Okay, Gideon, you are calling us from Siani. What's your question, Gideon? Good afternoon. Gideon, let's hear you. I can hear you, Gideon. Go ahead. Yes, go ahead.
Please, my question is, who's supposed to be at the land commission before they become comfortable?
Thank you very much. Thank you. Okay, there's too much noise in the background, particularly from Zoom. So let's hold on with it. Must you take your will to the Lands Commission to be stamped before it becomes effective?
No. It doesn't require stamping of any sort. No.
He seems to suggest to me that somebody is telling him that this is what must happen.
There's no requirement of law that you must take your it requires any form of stamping in order to be valid. The only thing the law requires is for a copy to be deposited in the registry of the High Court. That's about all.
Right. And going through that process, is the will open, people can see, or how does the court keep it?
When you go to court, you seal it. Your lawyer, if you've got a lawyer, you seal it. If you haven't got a lawyer, you seal it. All that you have to do is to tell them it's a testamentary script, and they will accept it, and they will log it in there. They've got a logbook in there. I think it's in alphabetical order according to the names of the testator.
Right.
And they will give you a receipt to show that on a particular day, this document, testamentary script, was deposited. And it is from that list that when the person is dead, the testator is dead, an application for probate is made. The registrar who received that document is required to bring the copy that he had with him to the court. And then the court will grant the probate. In addition to any one of the two witnesses, there is a form that they must sign as part of the application for probate in which they will acknowledge that either one of them was the person who witnessed the will. That's part of it.
Can you give assurance that when you are going to deposit the will, when the court takes it, they have a way of sealing it that you are assured that it's properly sealed?
Oh, they do. And they give you a copy. There's this, I've forgotten the name. It's this thing they light a candle to, then it drops. They've got a name for it. It's a wax.
Yeah.
It's a wax.
It's red.
And they've got, a red wax. There's a candle to it. So they light the candle, and as it begins to drop, they put it at the edges. That's to make sure that nobody can open it without there being evidentiary evidence that has been opened.
It has been broken.
Because the seal is pushed in such a way that there's no way you can tamper with it without breaking the whole thing.
So all the copies are sealed that way, and then one is kept with the court. You can keep one, put it under your bed somewhere if you want. There are people who deposit another with some other place where they are.
You know where the bank is?
Yeah, in the banks where they know it's safe. Some can actually deposit a copy with their lawyers too.
That is so.
Right.
In fact, I regularly keep copies of these wills.
Right.
We do.
Joe, okay, let's start with Odro. Odro, you are calling from Techiman.
Joe.
Hello?
Can I?
Yes, Joe, go ahead. Go ahead.
Yes,
You are calling from Afenya.
I'm asking whether a purported beneficiary of the will hold the will for 7 years. Then after 7 years, go to court. Get a lawyer to allow the will to be lodged in court.
That's a difficult question. You say a purported beneficiary.
Yes, of the will.
Okay.
That the will of the mother. Held the will for 7 years.
After the death.
After the death of the mother. Held the will for 7 years. Then after 7 years, went and deposited it got a lawyer, deposited it in the court.
I see.
Probate.
Deposited it first before they went for probate.
Yes, deposited after 7 years.
Okay, thank you. We'll come to you. Odro, you are calling from Techiman. Hello, Odro. I think I've lost Odro. Let me try. Last try. The guys on Zoom. The guys on Zoom. Can you observe setting, order? Now make sure you are muted. Once I invite you, then you unmute. Everybody is muted. I can see there's only one person who is still unmuted. Wesley, let's start with you.
Once I invite you, then you unmute.
Wesley, start. Okay, so Zoom, you are disappointing. Unfortunately, if we want to follow what's happening there, we will not make progress and time will catch up with us. So, yes, you answered the issue of the stamp. Now it's Joe who says somebody kept the mother's will for 7 years after death and then deposited and later went for probate.
Yeah, if he did it with the knowledge that he had a will, unless he found it by accident. But if there's clear evidence that he was aware of the existence of the will and he failed to deposit it, first, he has committed a criminal offense.
Right.
How the police deal with it is not the province of this discussion. But point number two, issues arise. When people die, there's no evidence that they've got a will, and then they go ahead and take letters of administration, and when that has been taken and the property has been distributed, and then
later
here comes up a will. And those issues are determined according to what has transpired. In other words, to the extent to which those properties, because to start with, the discovery of the well itself renders everything that has been done in the interim as null and void. But there are situations where other people have taken an interest in the property in between the time. Because if you took a letter subscription in the reasonable belief that there was no will and the property might have been sold to somebody else, then the issue arises as to how to unravel what has gone on. It all depends on the circumstances. It's too complex for us to discuss it, but on the basis of the assumption that everything was done innocently, life is not perfect. Then the people who acquire the interest in the interim with the knowledge, without any pride and command, without any knowledge of any fraud and stuff like that, would have acquired it lawfully. But there are ifs, and we have to know the particular situations to be able to discuss all the ramifications. But I'm just making the point that these issues arise. For real.
So you're still here on the law. And this is your health law, and it is your legal light. And my guest has been Kwaku Pinsel, head of Pinsel and Co. law firm. And I was thinking I could take one more of your questions because there are still too many of you hanging around. Just one favor to one more of you, and then he'll answer that, and our time is up. Thank you very much. We hope we have empowered you to some extent with such superior experiential, knowledge on how to make a will. Hello? Hello, Adams, go ahead with your question.
Yeah, my question is, supposing that I have 14 children, and I decide to will all my properties to just one of them. And after passing, has the law got a provision for, and the others come up and said that no, they will not agree to what has happened. They are disagreeing to the will.
Okay.
Has the law got any room for
improvement? Thank you. Thank you. Your question is understood. I think I can take this next person. Who is at the back there? Hello? Okay. When I was talking to Adams, you were, beeping behind. Okay, how do we respond to Adams?
A man is not obliged to give anything to anybody he doesn't want to give to. And I regularly come across words where a man will even name somebody and say, I give to this person, my executor should buy a Bible, King James Bible for the person. I give somebody 10 CDs. And they do it deliberately. They name you so that it does not appear as if they didn't remember you and whatever. Because there are children, so-called, who don't deserve a thing. They fought their fathers in their lifetime and stuff like that. So first, we go back to the same law. You must be beneath 18 years in order to be able to mount a challenge. For a wife, of course, there's a recent decision that I read. The Supreme Court has stated that has got nothing to do with the woman's conduct or character. But sometimes the men, why do we even keep talking about men? The testator has made other provisions in his lifetime. And if he does not, subject only to what the law says, that anybody is free to bring an application for reasonable provision to be made. But the law will treat a man's will as a sacred document and will rarely touch it. And so that is it. A man can make a will. We hear regularly in the UK, US, and people may will and leave their estate to their dogs, to their cats, and so forth. So that is it. You work all your life. What you got, you have a right to use it the way you want it. It's as simple as that. It's got nothing to do with children, nothing to do with wife, nothing to do with parents. Thank you. As the law has made a provision for.
Thank you so very much, Kwaku Pinsel. Kwaku Pinsel is head of Pinsel and Co. law firm, and he has been our guest on the law this afternoon. I'm Samson Ladi Anyanini, and this is your health law and your legal light. God willing, next week we'll come your way with yet another legal clinic to help you. Thank you very much. Have a good afternoon.